I believe that the technical staff is now prepared for us to begin, so we will do a countdown. 7, 6, 5, 4, 3, 2, 1. The Committee on House Administration will come to order. I want to say good morning to everyone. And as we begin, I want to note we're holding this hearing in person, but also in compliance with the regulations for committee proceedings pursuant to House Resolution 8. Members and witnesses were provided an opportunity to participate remotely if necessary. None of the witnesses are doing so for this proceeding. And of course, we have the members who are here at the days personally. I'm very pleased to see everyone here, and I note that we are holding this hearing in compliance with the most recent guidance issued by the Office of the Attending Physician. At this time, I ask unanimous consent that Chair be authorized to declare a recess of the committee at any point, and that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record, and hearing no objections, that is so ordered. For all of us who are fortunate enough to work in public service, a guiding principle should be that a public office is a public trust. Without the public's trust and confidence, government loses its legitimacy. That principle was of paramount importance to the founders. As the Federalist Papers put it, the aim of every political constitution is, or ought to be, first to obtain for rulers men who possess, I would add women as well, most wisdom to discern and most virtue to pursue the common good of the society. And in the next place, to take the most effectual precautions for keeping them virtuous whilst they continue to hold their public trust. Since the founding, this has remained a vital underpinning of our democracy and informed periodic reforms to address shortcomings in standards of conduct for public officials. For example, this week marked the 10th anniversary of the enactment of the Stock Act. That measure, which President Obama signed into law on April 4, 2012, amended the Ethics in Government Act of 1978 and imposed new financial disclosure requirements, among other provisions. Overwhelming bipartisan majorities decided then that the existing statutory framework to combat government corruption, improve financial disclosure and transparency, and curb financial conflicts of interest in government had to be strengthened. Or, as the founders might have put it, that more effectual precautions were necessary to keep our public officials virtuous while they continue to hold their public trust. Accordingly, the Stock Act enhanced public disclosure requirements by introducing a requirement to report securities transactions throughout the year closer in time to the transactions, rather than just the following year on an annual statement. Among other things, the Stock Act also affirmed that insider trading prohibitions apply to federal officials and clarified that all federal officials have a duty of confidentiality and trust to the United States and its citizens with respect to material, non-public information that they derive from their positions. These were important steps forward. A friend to many of us, the late Chairwoman Louise Slaughter, was the primary champion of the Stock Act and worked for years to see it passed into law, and it's fitting that Congress named the law in her honor. The 10th anniversary of the Stock Act would, on its own, provide a good opportunity to review how officials have complied with the law and whether there are ways it could be updated. Unfortunately, there have been examples in all branches of government that further reforms are needed. Consider the following examples brought to light by government oversight and ethics groups, several of whom are represented here today, in public reporting. Reporting by the Insider and other publications found that a member of Congress failed to file the periodic transaction reports required by the Stock Act on time. Reporting has also questioned whether members engaged in improper trading activities or have financial conflicts of interest. In the early weeks of the pandemic, several senators bought and sold millions of dollars in stock after attending closed-door confidential briefings with top national security and health experts on the pandemic and the looming economic shutdown. This included selling stocks that would soon take a hit after the stock market plunged and buying stock in industries that received a boom due to the pandemic, such as remote work technology, telemedicine companies, car companies manufacturing ventilators, and pharmaceutical makers developing vaccines. The Department of Justice reportedly reviewed the trading activity of several senators, and according to the Security and Exchange Commission, it is still investigating one senator's trading activities and related conduct. Also early in the pandemic, the chief of staff to then-President Trump sold between $250,000 and $500,000 in publicly traded securities the same day that President Trump said the economy was doing, quote, fantastically. The next day, the value of those holdings plummeted. At the Federal Reserve, multiple senior officials, including presidents of 2 of the Fed's 12 reserve banks, engaged in large financial transactions when the Fed was playing a key role in decisions about the nation's economy during the pandemic. Even before the pandemic, though, there were other troubling signs. The wealthiest president and the richest cabinet in modern history, which included a significant number of billionaires, also exposed how the law's disclosure requirements are out of date and particularly inadequate for the super-rich who become government officials. In one case, a former member of the House was investigated by both the Department of Justice and SEC for insider trading and other violations related to his actions in sharing insider information about a failed clinical trial in an Australian biotech company. He ultimately pleaded guilty to conspiracy to commit securities fraud and false statement charges, and he was sentenced to 26 months in prison, but former President Trump pardoned him and he was released. One Trump administration cabinet secretary, a billionaire, repeatedly came under criticism from the Office of Government Ethics for failing to abide by his ethics agreement and for repeated errors in his financial disclosure reports, errors significant enough that OGE determined it could not certify his reports. In the meantime, he reportedly made between $53 million and $127 million while heading the Commerce Department. And as Crew showed, it's possible that he earned even more than that, but we don't really know how much more due to the outdated loopholes in the disclosure laws. Last month, a federal judge imposed a penalty of more than $60,000 against a former Trump White House official after finding that she knowingly failed to file a financial disclosure report as required by law for more than a year, despite repeated warnings about her obligation to do so. In the judicial branch, as work by good government groups and reporting by the Wall Street Journal has revealed, there have been widespread problems with financial conflicts of interest and failures by judges to recuse themselves. According to those reports, between 2010 and 2018, more than 130 federal judges improperly heard hundreds of court cases in which they or their family members held stock in a party to the litigation. Under federal law, federal judges are required to recuse themselves from cases in which they or their spouse or minor child have a financial interest in the subject matter or party. Plus, the problem could be even worse than that. The judiciary is literally years behind in making judges' financial disclosures publicly available. Only this year will judges' annual financial disclosure filings covering 2019 finally be available. 2020 still won't be ready. By comparison, when a member of the House files a financial disclosure report, the clerk must make it publicly available within 30 days. Across the entire federal government, there have been significant and troubling stories about financial conflict of interest in relation to stock trading and ownership. Together, these stories undermine confidence that the American people should be able to have in the faith and the trust that they put in the integrity of public officials and our government. Members of the public may ask, are our public officials acting in the public interest or their private financial interest? In light of these events, the Speaker of the House tasked the Committee on House Administration with conducting a comprehensive review of deficiencies in our financial disclosure system and a review of various legislative proposals introduced by members to address financial conflicts of interest in Congress, including those that aim to restrict stock trading and ownership. Our hearing today is a continuation of our review of the diverse legislative reform proposals. While there's growing bipartisan consensus that reforms are necessary, there remain significant policy questions about the appropriate approach and the details. Today, we will have the opportunity to hear from well-respected experts in government ethics and security law and regulation about what has prompted a significant momentum for financial conflict of interest reforms, the details, variations, implications of various introduced bills, and specific policy recommendations for reform. It's our hope that this hearing today will bring us closer to developing a consensus on recommended policy reforms that will combat financial conflicts of interest and restore public faith and trust in our government. Frankly, I've been asked by several reporters, what is the work product that is going to emerge from this hearing? And I've been honest to say, we don't know. We've got a series of experts who are going to help us understand the intricacies of these issues and will help us in formulating good policy that will buck up trust in the American government. And we do thank the witnesses for their participation. I would now recognize the ranking member, or did you want to go to Mr. The ranking member for any statement he may wish to make.
Yeah, don't give style the glory of my opening statement here, Madam Chair. First questions, yes, but I mean, please. Nice to see you too, Ms. Spanberger. Shall we walk in? Welcome. Thank you, Chair Lofgren. I'm glad we are holding a hearing on this very important topic. The public has spoken, and the demand is clear. Americans want more certainty that their elected representatives are acting in good faith with their financial decisions. Today provides a unique opportunity to bring together experts from across the political spectrum to assess proposals on how best to move forward to increase transparency and accountability across Congress. I look forward to these discussions. I'm confident this hearing will serve to inform us as we move forward in the legislative process. I'd like to begin by discussing some of the financial transparency measures already in place. The intent of the 2012 Stock Act is good. It was meant to create a public disclosure system for members of Congress to report their trades in a timely manner. However, as we have witnessed on multiple occasions since its passage, the Stock Act has deficiencies, and compliance with its requirements is not as straightforward for members as it should be. We've given the Stock Act 10 years, and it's time for Congress to take another look at this issue. According to Business Insider, at least 59 members have reportedly violated the requirements of the Stock Act since 2019. These alleged violators come from both sides of the aisle, making this a bipartisan issue that requires a bipartisan response. Given the broad distribution of these alleged violations across the various ideological groups in Congress, I'm confident that the majority, if not all, of them weren't malicious but inadvertent, illustrating a failure on multiple levels. This particularly concerns me because it suggests that we are not adequately educating our incoming members on their responsibilities to comply with the Stock Act. It is the responsibility of this committee to ensure members are aware of their responsibilities when they come to Congress, and I pledge to fix this lapse for new Republican members. I'd ask the chair to join me in this initiative for any incoming members of her party. While the legislative fixes we discussed today are a critical step forward, I'd like to say also that this committee should hold further discussions on how best to educate and assist all members, especially freshman members, with compliance issues and questions so that we can achieve the transparency that the American people demand. The public and our members deserve better from this committee, and as ranking member, I will do everything I can to fix that. I'm sure the chair will agree with this sentiment, and I welcome the opportunity to work together on this bipartisan issue. Regarding potential Stock Act updates, I'm excited to hear from our witnesses today. Since this issue has captured the attention of the public, we have seen a wide range of proposals for reform. These suggestions are diverse, both in their proposed requirements and with their enforcement mechanisms to ensure compliance. Now, I don't really have many stock holdings other than retirement, but in anticipation of this hearing, I spoke with my financial advisor from my home district. It's actually my wife's financial advisor, a little bit of me, mostly her. He's from my home district in Illinois, and I wanted to get a better sense of how some of these proposals would affect members, especially middle-class members. He raised the concern that blind trusts, for example, can be cumbersome and expensive. would create perverse incentives and do not provide the level of transparency that some assume they would. For example, most financial firms won't even take on a client for a blind trust unless they meet certain asset holdings and activity requirements. I don't meet either of those requirements today. And I would guess that that's true for many members. But these cost restrictions would put us in a situation where these perverse incentives might force members to engage in more market trading in order to meet blind trust minimums and other requirements. I hope we can address some of these concerns here today because I'm sure many members of Congress share them with me. I'm hopeful that the majority will take this opportunity to work together to build a bipartisan solution instead of proceeding with a knee-jerk reaction that sends a one-party bill immediately to the floor. I look forward to our expert witnesses' testimony and further discussion, and I hope we can leave this hearing with a better understanding of the ramifications of any proposed solution as we embark on working together, hopefully, to craft bipartisan legislation. Thank you, and with that, I yield back.
Thank you, Mr. Davis, and excuse me, in just a moment, I'll introduce today's witnesses, but before I do, as a reminder to our witnesses, each of you is recognized for 5 minutes. There's a lighting system and a timer in front of you, and when your time is up, we ask you to try and wrap up. Your full written statements will be made part of the record and will inform not only this committee, but members of the public. And the record will remain open for at least 5 days after this hearing for additional material to be submitted, and we may also have additional questions for you, and if that is the case, we would ask that you respond to those questions. Let me introduce each of our witnesses. Jacob Strauss is a specialist on Congress at the Congressional Research Service, where he has worked since August of 2007. He specializes in American government and politics with a focus on Congress and other governmental institutions. He's an adjunct professor on governmental studies at Johns Hopkins University and an adjunct professor at the University of Maryland, Baltimore County, in the Political Science Department. Prior to that, he served as an assistant professor of political science at Frostburg State University. He holds a PhD in political science from the University of Florida, an MA in political science from the University of Florida, and a BA in government and politics from the University of Maryland. Liz Hempowitz serves as Director of Public Policy on the Project of Government Oversight, sometimes referred to as POGO. She is an expert on whistleblower protections, conflicts of interest, ethics, Freedom of Information Act, separation of powers, and the National Emergencies Act. She develops and advances policy solutions to combat corruption and promote openness and accountability in government, and she strategizes the best way to translate POGO report findings into legislative reforms or executive action. She has participated in efforts to improve the Inspector General Act, the National Emergencies Act, lobbying and congressional ethics rules, whistleblower protections, and the Freedom of Information Act and other government accountability issues. She graduated from the University of Bridgeport with a bachelor's in international political economy and diplomacy and earned her JD from American University's Washington College of Law. Donald Sherman, welcome. You serve as the Senior Vice President and Chief Counsel for Citizens for Responsibility and Ethics in Washington, otherwise known as CREW. He is a leading policy advisor on racial justice and equity, government ethics, and congressional investigations and oversight. He's served in various roles in the House, Senate, and executive branch, including as Special Assistant to the President for Racial and Economic Justice at the White House, Senior Counsel to Ranking Member Claire McCaskill on the Senate Homeland Security and Governmental Affairs Committee, and Chief Oversight Counsel to the late Representative Elijah Cummings, then Ranking Member of the House Committee on Oversight and Government Reform. Mr. Sherman began his career on Capitol Hill as counsel on the House Ethics Committee when I chaired that committee, and where he investigated allegations of ethical violations by members of Congress and staff. And prior to that, he practiced law in Washington, D.C. for Crowell & Mooring, LLP, and served as a law clerk to the Honorable Neil E. Kravitz of the District of Columbia Superior Court. He graduated from Georgetown University with a degree in American Studies and earned his JD from Georgetown University Law Center. Donna Nagy is the C. Ben Dutton Professor of Business Law at Indiana University's Maurer School of Law. She joined the law faculty in 2006 and teaches and writes in the area of securities litigation, securities regulation, and corporations. Her scholarship includes co-authoring 2 books, one on the law of insider trading and a case book on securities litigation and enforcement. She's written numerous law review articles on topics including the selective disclosure of government information, government officials and financial conflicts of interest, insider trading, and fiduciary principles. She is a member of the American Law Institute and served as an appointed member of the ABA Corporate Laws Committee. She also served a 3-year term as a member of the National Adjudicatory Council of the Financial Industry Regulatory Authority, and before teaching, she was an associate with the Debevoise and Plimpton in Washington, D.C., where she specialized in securities enforcement and litigation. She received her BA from Vassar College and her JD from NYU University Law School. And finally, Jennifer Schulp is the Director of Financial Regulation Studies at the Cato Institute's Center for Monetary and Financial Alternatives, where she focuses on the regulation of securities and capital markets. Prior to joining Cato, Ms. Schulp was the director in the Department of Enforcement at the Financial Industry Regulatory Authority, where she represented FINRA investigations and disciplinary proceedings relating to violations of federal security laws and self-regulatory organization rules. Before joining FINRA, Ms. Schulp was a litigation associate at Gibson, Dunn & Crutcher, and she clerked for the Honorable E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. She received her J.D. from the University of Chicago Law School and her A.B. in Political Science from the University of Chicago. As all can see, we have a very distinguished panel of witnesses before us. We do thank you, and we will now hear from you for 5 minutes each, and we will start with you, Mr. Strauss.
Chairman Lofgren, Ranking Member Davis, and members of the committee, on behalf of the Congressional Research Service, thank you for the opportunity to appear today. My testimony focuses on 2 areas: current financial disclosure and periodic transaction reporting requirements, and legislative proposals introduced during the 117th Congress to limit or prohibit certain financial transactions by members of Congress and covered congressional employees. Federal government officials and employees, including members of Congress, when taking official action, are expected to, quote, place loyalty to the Constitution, laws, and ethical principles above private gain. Using this guiding principle, the Ethics in Government Act, as amended, including by the Stock Act in 2012, requires covered officials, including members of Congress and certain congressional employees, to file annual financial disclosure statements that report income, gifts, liabilities, and property, and make periodic transaction reports that disclose the purchase or sale of certain financial assets. Further, the Stock Act affirms that members of Congress, congressional employees, and other federal officials are not exempt from insider trading laws. In the 117th Congress, as of March 1st, 2022, CRS identified 14 bills or resolutions that propose limitations on members of Congress and other covered congressional employees from engaging in certain financial transactions. Broadly, these measures propose to amend the Ethics in Government Act and/or the Stock Act, create new law, or amend House rules to prohibit the holding, purchasing, selling, and/or actively managing certain types of assets. Currently, Congress does not prohibit the ownership of specified financial assets, but certain targeted restrictions do exist in some executive branch agencies. With regard to the legislative proposals before Congress, 6 points are pertinent. First, to address member and covered individuals' financial holdings and transactions, several legislative proposals would either amend the Ethics in Government Act, the Stock Act, or both. Others would create new law. Second, each of the legislative proposals would generally prohibit covered officials from holding, purchasing, selling, and/or actively managing certain types of assets. Third, a number of the proposals would allow or require a member of Congress to place covered assets in a qualified blind trust that is approved by the official supervising ethics office, the House Ethics Committee for the House of Representatives. Qualified blind trusts separate the covered official from day-to-day decision-making about their holdings, which can serve to remedy potential conflicts that might arise from officials' actions that could impact their individual holdings. Fourth, 4 of the proposals would expand public access to information in the financial disclosure statements in periodic transaction reports. Fifth, 10 of the 14 legislative proposals would change available penalties for noncompliance. Within these proposals, 2 basic penalty strategies are suggested: fine individuals for noncompliance and/or publish the names of individuals who are found in violation of the law on a public webpage. Finally, 2 legislative proposals would amend House Rule 23, the House Code of Conduct, to add a new section that would prohibit members from trading stocks. In closing, these legislative proposals include a range of options to limit or prohibit certain financial activities. Policymakers may wish to consider the scope of these proposals, the benefits of particular proposals, any potential administrative adjustments that might be necessary to implement a modification of ethics laws, and the potential costs to covered officials to comply with the proposed laws. My written testimony raises particular questions that might be considered. Should Congress choose to act, it could implement a particular measure as introduced or incorporate various concepts from several different measures. Each choice likely has advantages and disadvantages that CRS is available to discuss further. Thank you again for the opportunity to testify. I look forward to your questions.
Thank you very much for your testimony and also your willingness to continue to work with us as we sort through the various proposals. Ms. Hempowitz, you are now recognized.
Chairperson Lofgren, Ranking Member Davis, and members of the committee. Thank you for inviting me to testify today about addressing conflicts of interest in Congress as they relate to the owning of individual stocks. There is no denying that this issue has captured public attention in a unique way. In fact, a strong majority of voters from both major political parties support a congressional stock ban. A Fox News poll recently found 70% of those surveyed favored banning members of Congress and their immediate family and staff from trading stocks. Those numbers didn't come out of nowhere. An avalanche of eye-opening press coverage has demonstrated a congressional stock trading problem that ranges from seemingly benign missed public disclosure deadlines to criminal insider trading. In response, there are now entire online communities dedicated to tracking congressional sales, not only to hold members accountable, but because many members of Congress outperform the market and an enterprising few in the public want in on the action. It's no wonder that the polling reflects an overwhelming desire for change. And Congress is listening. More than 125 members are now co-sponsoring legislation intended to address at least some aspects of this problem. It is encouraging to see elected officials so in tune with what their constituents want. And so now Congress is poised to restrict stock trading by lawmakers with bipartisan support, and we are here to help hammer out the details. But the details are everything. There are several competing bills in both chambers of Congress, and when we see legislation advance, it will either be a first step towards creating real ethics rules for members of Congress or mere window dressing for legalized corruption. So I want to spend the few minutes I have with you today talking about what we at POGO see as some of the important bright lines for you to consider as you move forward. First, as a floor, we recommend that you require members of Congress to divest conflicting assets with the option to put any remaining assets in a blind trust that is subject to new public disclosures. The logic here is simple. Members of Congress have access to non-public information and the power to move markets. We must eliminate opportunities for insider trading and insulate members from even the perception that they are making decisions based on the benefits to their own financial interest rather than the public interest. Second, to be meaningful, these requirements must cover spouses and minor children. Again, the reasoning is simple. It is a safe presumption that married partners discuss their work dealings and that a minor child's affairs are under some modicum of their parent's supervision. Now, in both cases, that means the spouse or child also has the same access to market-moving information that the public is so concerned about being misused. In a less generous reading, exempting spouses or minor children would supply an easy, opaque way for a corrupt member to hide self-dealing and make any added restrictions totally moot. Third, the new standards cannot exempt assets that were owned before taking office. Unless members of Congress are willing to recuse from votes or committee assignments based on their financial holdings prior to taking office, an exemption for previously held assets creates a potential conflict without serving any discernible public policy objective. I want to be clear. POGO wants a much stricter ban than any of those you are considering today. We would limit the holdings that members, their spouses, dependent children, and senior staffers can own to diversified mutual funds and U.S. Treasury bonds, with narrow exemptions applicable only in truly unusual circumstances. But today, we've focused our bright lines on improvements to the law that will enhance accountability and public trust related to concerns about insider trading. And there is incredible momentum for these reforms that would respond directly to one of the public's most acutely expressed institutional concerns. But now, some have suggested that Congress should slow down this current effort so that it may include reforms to the financial conflicts of interest systems that apply to the judiciary and the executive branch. But you face the very real possibility of passing no reforms if you slow down now. I urge you to focus first on passing restrictions for Congress and then use that momentum to pass additional and, yes, critically necessary conflicts of interest reforms to the other branches of government. I want to close with this thought. The reason we're having this conversation today isn't because of any one scandal or missed Stock Act filing deadline. We're here because the barrage of the many different examples across both chambers and parties has given the public an overwhelming perception that Congress is engaged in corrupt behavior when members are allowed to freely own individual stocks. My colleagues at the Project on Government Oversight stand by ready to aid in your efforts in addressing this problem however we can. Thank you again. I look forward to your questions.
Thank you very much. Mr. Sherman, you're now recognized.
Chairperson Lofgren, Ranking Member Davis, and members of the committee. Thank you for the opportunity to appear before you today to address the ethics problems created when members of Congress and their families own or trade individual stocks and other securities. I'm especially grateful for this opportunity to testify before Chairperson Lofgren, who, 13 years ago, hired me to join the nonpartisan staff of the House Ethics Committee. My organization, Citizens for Responsibility and Ethics in Washington, is a nonpartisan anti-corruption watchdog committed to ensuring that government officials act ethically on behalf of the people they serve. It is with this purpose in mind that I encourage Congress to embrace comprehensive legislation that satisfies three principles. 1, prohibiting members from owning and trading stocks and other similar commodities or securities. 2, extending this prohibition to members' spouses and dependent children. And 3, incorporating a clear civil penalty that is a significant deterrent and easy to administer. In addition to these priorities, Congress must also ensure that any relevant oversight and enforcement bodies have the authority and the resources necessary to do their jobs effectively and to provide the public with real transparency. The ethics problems posed by members of Congress owning and trading stocks are not theoretical. At the beginning of the pandemic, a moment when public confidence in our government was critical, Congress was rocked by scandal. Reports of senators making significant financial transactions following private briefings about the coronavirus pandemic were just the tip of the iceberg. At least 75 members of Congress owned shares in COVID-19 vaccine makers Pfizer, Moderna, and Johnson & Johnson in 2020. These members were asked repeatedly to vote on legislation that impacted these companies' share prices. Similar issues have been spotted in other sectors. For example, 15 members that sit on committees overseeing U.S. military policy have financial ties to military contractors worth nearly $1 million. These facts are both egregious and, sadly, unremarkable. One reason for this litany of questionable conduct is the weakness of our current legal regime. The Stock Act, passed in 2012 to ensure that members do not trade on non-public information gained through their government jobs and to enforce public transparency of their holdings, has failed to police this kind of behavior. Exposing Stock Act violations has proven difficult, in part because periodic transaction reports and financial disclosures are hard to access Still, the near constant drumbeat of repeated and reported violations is a death by 1,000 cuts for the credibility of this institution. Since the passage of the Stock Act, there have also been significant changes that give individual members even greater ability to affect the market. Members now have a much larger presence on social media, enabling them to impact corporate stock prices with a single tweet. Congress has expanded the power of committee chairs to issue unilateral subpoenas, and a growing number of members are conducting oversight from their personal offices. Congressional rules need to change to help address members' expanded ability to influence the market. Banning members from owning or trading individual stocks would address several problems, including the actual conflicts of interest that arise when they take official actions that impact a company or industry where they or their families have a direct financial stake, the appearance of financial conflicts of interest, and the public outrage over members appearing to trade on confidential information. A ban is necessary because, unlike other officials in other branches of government, recusal is not a viable option for members of Congress. Yet both the executive and judicial branches have higher standards. Merely placing individual assets into a qualified blind trust will not fully address these concerns, absent a requirement to sell the original assets. The ban must also extend to members' spouses and dependent children to ensure that members can't simply circumvent the law by transferring their individual assets to a close family member. Finally, the ban must include an enforcement mechanism that is both clear and significant enough to serve as a deterrent. For example, the legislation should not create a standard of intent that would make enforcement unlikely. While it is understandable that some members may have questions about the impact of these reforms on their own or their family's interests, these concerns are not more important than the public's right to know with certainty that the people they choose to write their laws are acting on their behalf and not in the service of their own financial interests. In closing, the public is right to hold their representatives in Congress to the highest ethical standards and to demand accountability when those representatives fail to live up to them. Wide bipartisan majorities are demanding that Congress make changes to address members buying and owning stock in industries that they oversee. Banning this practice will help to restore public faith and bolster confidence in our democracy. Thank you for the opportunity to address the committee today. I look forward to your questions.
Thank you. We'll turn now to Professor Nagy.
Chairman Lofgren, Ranking Member Davis, and members of the committee, thank you for inviting me to testify. I have been teaching and writing about corporate and securities law for more than 27 years. For nearly half of that time, I've also been writing about government ethics. What first drew me to that field were the controversies that resulted in the Stock Act of 2012. I had the great privilege of testifying about insider trading law in the House and Senate hearings that preceded that legislation. In connection with today's hearing, what I can also bring to the table are my years of studying how conflicts of interest undermine the legitimacy of decision-making by officials entrusted with power. Whether the decision-making occurs by corporate directors inside a boardroom or by lawmakers here in the Capitol, financial conflicts of interest contribute to a corrosive belief that those entrusted with power are making self-serving decisions that may not be in the best interest of those they've been elected to serve. My testimony today strongly supports your efforts toward reform, and I have 4 points to highlight. The first emphasizes a key difference in the many bills I've reviewed. Whereas some seek to restrict the ownership of certain investments by members of Congress, others seek to restrict only the trading of such investments during congressional service. In my view, trading restrictions alone will not be an effective solution to the conflict of interest problem that is plaguing Congress. Successful reform must also reduce lawmakers' opportunities for personal gains in their investment portfolios when they sponsor, support, oppose, and vote on legislation. So I urge this committee to focus on ownership and not merely trading. What is most needed, in my opinion, is a federal statute that prohibits members of Congress and their spouses and dependent children from owning the securities of individual publicly traded companies. My second point contrasts the lax conflict of interest restraints that currently operate in the legislative branch with the very strict anti-conflict laws that Congress has enacted for officials in the executive and judicial branches. To be sure, ethic rules in both chambers prohibit members from deriving personal financial benefit from congressional service. But longstanding interpretations permit and facilitate a lawmaker's ability to work and vote on legislation likely to affect their own investments, so long as they are not the sole beneficiaries. The lack of parity among the three branches underscores the urgent need for reform. My third point refutes the notion that public disclosure of personal investments, coupled with the discipline of the electoral process, can adequately deter these troubling financial conflicts. Neither annual ownership disclosures nor specific 45-day transaction reporting has managed to deter lawmakers from owning and trading hundreds of millions of dollars in stock in companies subject to their oversight. If anything, it has made the perception of corruption worse because, thanks to journalists and good government groups, the American public now sees even more quickly how frequently and extensively some lawmakers are benefiting from their legislative activity. Moreover, self-interested legislative activity affects the entire country, whereas only voters in a member's district or state can have a say in whether conflicts are serious enough to warrant an electoral defeat. My final point relates to insider trading. Notwithstanding the clarity brought about by the Stock Act, investigating suspicious trading by congressional officials has proven to be more challenging for the SEC and the DOJ than most may have supposed a decade ago. The Constitution's speech or debate clause puts in place a very high hurdle for obtaining evidence that relates to what a congressional official learned through legislative activity. And without evidence, prosecutions are not possible. This hearing constitutes a monumental step toward bringing about real and profound change. I am truly honored to be a part of it. I look forward to your questions, and I stand ready to be of whatever help I can as the legislative process progresses. Thank you very much.
Thank you. Excuse me. Thank you very much. And now we have our final witness, Ms. Schulp. We will welcome your testimony.
Thank you. Chair Lofgren, Ranking Member Davis, and distinguished members of the Committee on House Administration. My name is Jennifer Schulp, and I am the Director of Financial Regulation Studies at the Cato Institute Center for Monetary and Financial Alternatives. Thank you for the opportunity to take part in today's hearing. As you know, the questions raised by members of Congress trading stocks are not new. A decade ago, the Stock Act clarified the applicability of insider trading prohibitions to lawmakers and required periodic disclosure of stock transactions. But concerns have persisted about lawmaker stock trading. Although recent polling shows widespread public support for banning lawmakers from owning or trading stocks, such measures are too broad for preventing insider trading and too narrow to effectively address the question of financial conflicts of interest. Because financial conflicts of interest present complex trade-offs, not easily solved by a simple prohibition, it is better to focus on increasing transparency through disclosure. Despite headlines to the contrary, there is little evidence that unlawful insider trading is widespread on Capitol Hill. Recent research looking at post-Stock Act trading data has found that lawmakers do not reap outsized returns, including for investments in areas where lawmakers hold committee assignments. Yet, questionable trading has fed a public perception that lawmakers have financial advantages. Analyzing lawmakers' trading is more than fair and has been made possible, in part, by the Stock Act's reporting requirements. But current law already delineates when such trading is unlawful. It does not follow that all stock ownership or trading should be prohibited just because no Stock Act prosecutions have been brought. This is especially true where there is no evidence of widespread insider trading. Moreover, taking prophylactic action to combat insider trading does not address the actual issue. There is reason to believe that those calling for congressional stock trading reform are not motivated by a crisis of faith in the markets, but rather a lack of trust in lawmakers. A focus solely on individual stocks distracts from the broader issue that the public perceives lawmakers to be using their positions for financial gain. Members of Congress are uniquely positioned to not only have access to information impacting stock values, but also the ability to influence those values directly and indirectly. But this complication exists not only for individual stocks, but for mutual funds, exchange-traded funds, crypto holdings, business interests, and other financial interests. Individual stock restrictions address only a narrow portion of these potential conflicts, and as such, may do little in the long term to enhance voters' trust in Congress. The question, then, is how to manage this multitude of potential conflicts. While it is tempting to say that conflicts should be eliminated, this solution is not practical across the range of potential financial conflicts of interest that lawmakers face. Importantly, seeking to eliminate a particular conflict, such as trading in individual stocks, may have unintended effects on the quality of representation that voters receive, either by discouraging some from running for office or by decreasing the connectedness between representatives and the impact of their decisions. Disclosure provides a more complete solution, bringing the conduct of lawmakers into the light, discouraging questionable trading, and providing voters with information about the conflicts of interest that their representatives face. The Stock Act provides a good foundation for this transparency, but it has fallen short of its potential, and enhancements should be considered to provide additional transparency. The first place to focus is on ensuring that penalties for noncompliance are consistently applied. It is worth examining whether the penalty framework is sufficiently deterrent and considering public reporting of delinquent disclosure. And it is also worth considering whether aspects of reporting can be automated to ease compliance burdens. Second, the disclosure requirements themselves could be improved, for example, by shortening the long lag between the execution of a trade and the deadline for disclosure. Enhancing transparency permits voters to choose whether the conflicts faced by their elected representatives are problematic, even if the trading itself is perfectly legal. Empowering voters with information limits unintended consequences of restrictions and puts the choice in the hands of voters where it belongs. Thank you, and I welcome any questions that you may have.
Thank you very much, and thanks to each one of our witnesses for very useful testimony. This is the time when members can address the witnesses with questions, and Mr. Stile is recognized at the request of the ranking member to go first.
Thank you very much, Madam Chairwoman. We have conflicting hearings today, and so I appreciate your willingness to let me jump in. I think where we maybe should begin is, one, what's legal and illegal under current law, and two, what are the priorities and objectives and goals of putting forth this framework? And so as I look at this, and Ms. Schlupp, I'd love for you to comment on this, it's to facilitate compliance with the law, and under current law, insider trading's illegal, including for members of Congress. We can have a conversation about the enforcement of that. Using information derived from one's position here in Congress is illegal under current law. We can have a conversation about enforcement mechanisms of that. And so compliance of the law, I think, is a key principle that we should be looking at. Ensuring members, family, and staff don't take unfair advantage of information gained from their congressional work, I think, is an important topic for us to consider as we look at this. And to provide confidence to the American people that we are in compliance with that we avoid the appearance of an impropriety. I think those are three key principles amongst others. Are there other key principles that you think that we should consider before I begin my questioning here?
I believe that those are the key principles here. You're correct that insider trading is already illegal.
Okay, so then let's dive in. We've heard a series of ways that we could enhance this to make sure that we're avoiding the appearance of impropriety, that we enforce the law, and we make sure that members are in compliance with that law. Let's dive in first to the blind trust. The compliance costs as it relates to a blind trust? What would be the compliance costs for members in a blind trust scenario?
Compliance costs for blind trusts tend to be substantial. Usually takes multiple thousands of dollars to set one up.
Okay,
and
so,
there's an
so
ongoing.
no, I'm just going to move quickly because I'm limited in time. So it's substantial. We could decide whether or not that's good or bad, but it's a substantial cost. And then would members of the public have confidence in the execution of the blind trust? Meaning a blind trust is only as good as it is blind. Is that a fair assessment?
That's a fair assessment.
So the structure of that blind trust then becomes absolutely paramount if Congress chose to go down that path. Let's shift gears, a complete stock trading ban. Thinking about the implementation of that, so envision a member of Congress coming here, say she was previously an executive at a publicly traded company, she has a significant portfolio. Would she then be required to divest that entire portfolio upon arrival in Congress?
Some of the proposals would require that.
And what would happen if somebody had to fully divest, if she had to fully divest her portfolio, what would be the general implications to her?
The first is that there could be substantial tax consequences for that, and depending on where the market is, it could be substantial losses to her investment.
So, or substantial gains, but,
Yes.
but substantial tax implications for her upon arrival, and maybe a consideration as to whether or not she chooses to run in the first place. I think something worthwhile for us to consider is how we would begin that implementation for somebody who arrives in that capacity. Let me shift gears slightly for something that I don't think we've talked a ton about. I used to work in a publicly traded company. I was involved in the enforcement of Section 16A officers, their compliance with securities laws. Our securities laws gives us a framework with which to understand how publicly traded companies deal with this insider information, the appearance of impropriety for those insiders as well. Do you think that members should be banned from what I'm going to call sophisticated trades, swaps, options, shorting stocks? Would that improve would that improve the public's confidence that members are not engaging in insider trading?
No, I think it'll have little difference on the public's confidence in that front.
Okay. I may not fully agree with that. I think there's some opportunities that we may want to consider and look in that space. Let me shift gears then, in particular with other ways of adjusting the protocols to accomplish the same benefit without maybe a full ban of stocks, just to explore this space. Would minimum holding periods improve the public's confidence in members of Congress abiding by the law?
It may have some effect.
So if you had a, say, just for sake of throwing a number out, if you had a 90-day minimum holding period to remove quick movements in and out of stocks, it would be longer than the duration of a publicly traded company's financial reporting. It may improve the confidence of the American people in members.
There may be some effect.
May be worth us considering that. The other is our current regime has a disclosure after the sale of stock. Some public companies have gone forward with a disclosure prior to the sale or acquisition, a delayed closing, if you will. Say, for sake of discussion, 10 days, where an announcement would be made 10 days in advance prior to the sale or acquisition of a stock. Would that alter the appearance of the impropriety as people would be analyzing a member of Congress or another insider from engaging in a trade?
It may have some effect.
And would the burden placed upon that member or a spouse be significant or lighter than a blind trust scenario or a forced sale?
It should be lighter than a blind trust or a forced sale.
I appreciate your insights today. Cognizant of the time, Madam Chair, I yield back.
Gentleman yields back. Mr. Butterfield is recognized.
Thank you very much, Madam Chair, and thank you for convening this very, very important hearing today. And I especially want to thank the 5 witnesses for your testimony as well. Mr. Sherman, it's good to see you again.
Good to see you again,
I was
sir.
on the Ethics Committee when you served as counsel to the Ethics Committee, and looks like you've landed well. I just want to thank you for your many years of service. You know, Madam Chair, you were the chairman of the Ethics Committee when I was there. I will say publicly that out of the 18 years that I've served in Congress, those 2 years or 4 years on the Ethics Committee were the worst years of my life.
I don't take it personally because I concur.
And it had nothing to do with you, Madam Chair. I had, oh, you, Mr. Sherman. I had spent 30 years in a courtroom before coming to Congress. And, you know, in a courtroom, the rules are so much different than the rules for ethics for members of Congress. One, for example, there's a presumption of guilt. I don't know if members really fully know that or appreciate it if you have not been confronted with an ethics violation. But there's a presumption of guilt, and the burden of proof is on the member to prove that she is not guilty of the offense for which she is charged. And that was just so different from what I had been exposed to in a courtroom. And the final thing that I found very interesting was that a member's failure to cooperate with the process was deemed to be a violation of the ethics rule. And so when I say those were some very difficult years, they were. But while I'm with you, Mr. Chairman, let me just start with you. You have testified that your organization recommends a legislative proposal that requires a comprehensive ban on both trading and ownership of individual stocks and other securities by members and their spouses and dependents. So my question to you, and I have great respect for CREW, what is CREW's perspective of the various legislative proposals that ban stock trading but permit stock ownership through the use of qualified blind trusts, which are currently allowed by law? I know you touched on it earlier, but if you would be a little bit more illuminating in your response.
Absolutely, and thank you for the question. I think the misnomer with respect to qualified blind trust is that it only works if it's truly blind. Our position is that qualified blind trust could be a useful option if the member is required to effectuate the sale of all of the assets that would go into that trust beforehand, right? A trust can't be blind if the member knows that they own Microsoft the day before it went into the trust. They know that they still own it the day after.
Let's talk about judges. Half of my legal career, I was a judge back in North Carolina, and I have great interest in judicial service. But does your organization have any recommendation for addressing the crisis of widespread recusal failure to recuse, and lack of transparency regarding financial conflicts of interest in the judicial branch, in the federal judicial branch?
Absolutely. I agree with you that the conflict of interest issues that have arisen in the federal judiciary and been exposed through detailed reporting are a crisis of confidence and need to be addressed by the Congress. I would note, though, that one distinction between the ethics regime that applies to the federal judiciary versus members of Congress is that recusal is an option. The problem with the federal judiciary is that judges didn't recuse. Here in Congress, recusal is not a viable option for members of Congress that have a financial conflict of interest because it denies their constituents effective representation in this body.
And finally, Professor Nagy, I can't pronounce that exactly, but thank you for your service. Thank you for your testimony. Thank you for your testimony 13 years ago, or whenever you testified before the Stock Act was passed. Some people have argued that new prohibitions on stock trading activity or ownership are unnecessary. Some are actually saying that. They're saying it because public disclosure in the electoral process should be enough. It should be sufficient to address conflicts of interest. And they argue that disclosure allows for the public and good government groups to track trading activity and assess whether elected officials have acted ethically, and that informed by those disclosures, voters can remove unethical lawmakers at the ballot box. That seems extreme to me. What is your perspective on this argument?
Well, my perspective is that in 1978, Congress enacted the Ethics in Government Act with disclosure as the solution or the proposed solution for the conflicts of interest. 10 years ago in the Stock Act, we put in transparency reporting requirements where 45 days after, and disclosure hasn't worked. If anything, disclosure of financial transactions puts it glaringly obvious to the public that the conflicts of interest are there. The voters decide, let the voters in the ballot box decide. That reflects a misconception of the corrosiveness that conflicts of interest have. A voter only in one district decides the answer for that representative, but that representative's conflicts affect us all.
I agree, absolutely. Thank you. I yield back.
Gentleman yields back. The ranking member is recognized.
Thank you, Madam Chair. This is a very interesting hearing. I appreciate all the witnesses' testimony, and I'm hoping that some of the witnesses' testimony hasn't already led the majority to kind of assess what type of legislative proposal they're going to put forth, because I think the discussion we're having today is too important to not take a step back and understand where we are as an institution. And there's a common theme here that corrupt people do corrupt things, right? And we should make sure that corrupt people don't have an opportunity to do that. But our goal also is to make sure that those who want to follow the law and those who want to follow transparency measures have the ability to do so without being labeled corrupt. That's our charge. Our charge is to develop something that makes the public comfortable that we as members of Congress are transparent in what we do financially, but at the same time, we're working through a prism of testimony that was based upon corrupt individuals. Did any of you research or log into our financial disclosure portal before you came here to testify today? Raise your hand if you did. Okay? Any of you look at mine? Raise your hand if you did. Nobody? Why wouldn't you? Why wouldn't you look at our disclosures, those of us who are questioning you? Because if you did, you would see that I don't trade a lot of stocks. I got my only individual stock holding when I was a child because my father happened to work as a franchisee for a corporation called McDonald's. I haven't traded that stock since I got here. My kids, my dependent children, have that same asset. You know one reason I don't trade it? Because I don't want to go through the paperwork of the Stock Act reporting requirements. However, because I've owned this stock since I was a child, much of your testimony says that maybe I should sell it, right? Now, since I own that one stock, Mr. Sherman, I got a question for you. I was really interested in the comment that you said that owning and trading individual securities undermines the critical work of the entire federal government. Does my owning an individual stock since my childhood, undermine the credibility of the federal government?
I think it is reasonable for any constituent to question whether their members' stock ownership
They can do that at the ballot
has
box.
an
I'm going to
impact
reclaim my time real quick
their
because I want to go a little
legislative work.
further on this.
Sure.
So now that I'm a member of Congress and I own that one stock, my dependent children own similar stock that they were gifted. My wife does not. So if I go to, let's say, a McDonald's restaurant, because that's the only stock that I've owned since a child, and buy lunch, is that something that's unethical?
Certainly not. I think we need to craft ethics policy around the concept of, one, public service is a public trust, and we need to design a policy that would give the public the greatest confidence that their elected representatives and the body as a whole does not have financial conflicts of interest and that members aren't acting on them.
Well, it took me about 2 minutes to find my disclosure. I would urge you all to go in and find out if any of us here have any so-called conflicts of interest, because we need a baseline. We need a baseline of what all of you experts think would be a conflict of interest, because we think we're complying with all of the rules and requirements that we need. Ms. Nagy, I'm interested in your testimony. You talked about the placement of you testified the placement of accumulated assets into QBTs, qualified blind trusts, is only a minimally effective anti-conflict measure. How much does it normally take to actually have a financial company offer you a blind trust? Don't they have minimums, minimum investments? What are they?
I think it varies according to the financial companies, but it's a significant amount of assets.
It's a significant amount. My wife, because her financial advisor is a friend of ours, and because of our reporting requirements, he is not allowed to change any investments in her mutual funds on any given year, because it's very difficult to comply, and we want to be sure. We want to do the right thing here. But I asked my financial advisor, her financial advisor, how much the minimum amount would be. You can go look at how many stocks I own, which again is one, and I am nowhere near the minimal amount for a $500,000 minimum investment to create a qualified blind trust. Are you all aware of those limitations? Do you know how many members of Congress would have that amount of money to put into a qualified blind trust? Anyone?
May I respond?
Sure.
Yeah, I think it's important to remember when we're talking about blind trusts that I don't think any of the legislation that's in front of Congress would force a member to take advantage of the blind trust. The option is given to members who would choose not to divest. We see that same structure in the executive branch, and for the most part, most individuals going in who are subject to very similar restrictions in the executive branch choose to divest, including very successful millionaires and billionaires
Are there
that go
tax
into the
incentives for
executive branch.
divesting as a member of the executive branch?
You can receive in the same way that I think some of the legislation would include here, if members are selling their stock and they would incur a penalty, they would be able to get a certificate of divestiture, which would put off it wouldn't give them a benefit and it wouldn't give them a tax penalty. It would simply maintain their status quo until after their government service, and then they would have to pay whatever taxes they would have had to pay on those assets, whatever they did with them whenever. Which is the same thing they do in the executive branch, sir.
All right, I know I'm out of time, but Mr. Sherman did raise his hand. Do you know the number of members of Congress that would be able to afford that?
I don't, but as my colleague, Ms. Hempowitz, mentioned, divestment is an option, and it's an option that I think is preferable from the standpoint of certainly of crew, and QBTs may work for some members, but there are other options that members should avail themselves of if they pass a ban.
Forced divestment is the option you're talking about, right?
Well, you use force. I would say that being in public service is a choice.
It is a choice.
And so the
that's
choice
what I'm
to
concerned
divest.
about with many of the proposals that are out there, that the choice for those who are not independently wealthy is going to be limited compared to those who are wealthy and can afford a qualified blind trust.
I certainly am aware that there are more limited choices for individuals with less net worth than those with more, and I think this is another example of that, but I think divestment remains a viable option.
Gentleman yields back. Mr. Aguilar is recognized.
Thank you, Madam Chair, and I appreciate you holding this hearing and the opportunity to hear from our witnesses. Despite what the ranking member said, my belief, and I feel I speak for folks on our side here, is this is about gathering more information. This is about ensuring that we need to hold ourselves to the highest ethical standards, to realize that we need to follow the letter and the spirit of the law, and to recognize that there might need to be some changes along the way, and that the idea of crafting good public policy means that we have to weigh options and weigh equities, and that individuals who run for this office have to make choices on what public service and public sacrifice means. And so I appreciate hearing the information and reading the testimony as well. Ms. Nagy, there have been ongoing conversations about the scope of covered persons within stock trading and ownership. Should stock trading reform efforts capture members alone, or should they include dependent children and the covered individuals, senior staff members? What's the importance of the scope being widened here?
Sure. Thank you, Representative Aguilar. So I think the importance of the scope being wider relates to my very first point, which is that if the concern is a conflict of interest concern about the ownership of securities, and if the concern is that a member of Congress may be tempted into self-interested decision-making, then that self-interested decision-making is also going to relate to one's spouse and potentially to one's dependent children, who that lawmaker has control often of the assets. And so insider trading issues and trading issues are serious ones, but conflict of interest ones are very serious as well. And that is the area where Congress and the rules that apply to Congress and the laws that apply to Congress are very, very different than what currently applies in the executive branch and the judicial branch.
I appreciate that. Ms. Sempowitz, and then I'll go again to Ms. Nagy on this question. There's been debate over the ideal enforcement mechanism within the Stock Act. Some potential bodies, SEC, Securities and Exchange Commission, Department of Justice, Office of Special Counsel. What are some of the challenges facing these specific enforcement mechanisms?
Yeah, I think when we're talking about enforcement mechanisms that'll go through the executive branch, we're going to run into speech and debate issues. Our preferred enforcement mechanism runs through Congress. It's the one that you can see. I'm sorry that these bills all run together at this point, but I think it's the ban conflicting. It's the ban conflicting stock trading act, and it's the one led in the Senate by Senator Ossoff. And I think that one has the clearest enforcement mechanism. And I think the high-level principles to consider with an enforcement mechanism is that it is, any penalties would be meaningful, that it would be easy and simple to apply, and that the public can have confidence that it's being applied evenly across the board. And so there has to be some transparency there. And so I think those are the three high-level principles. But if you're asking what my preferred mechanism is, it's the one in the bill led by Senator Ossoff.
Ms. Nagy?
The enforcement mechanism could get more complicated when there are various options to divest or put in a blind trust. I think the administration of blind trusts would be, the administrative challenges would be immense. And if we look at the difficulties that members have had in complying with the Stock Act's 45-day reporting requirements, adding more disclosures, more forms, more supervision does not seem to me the way to remedy the current problem. I think the enforcement mechanism, the simplest one, is to say that members of Congress cannot own covered securities, exempt certain types of securities like widely held diversified mutual funds, treasury bills, others. There might be some other exceptions, and I think drilling down to that. The simpler the prohibition, the easier the enforcement.
I appreciate it. Mr. Sherman, you were the only one that mentioned, I'm sorry, you may not be the only one, but you specifically mentioned federal resources and oversight mechanisms. And can you talk with me briefly about how we bolster the enforcement bodies to improve our ability to tackle insider trading and other conflicts?
Absolutely. I think it's incumbent upon this committee to speak to the enforcement bodies, whether that's the OCE or the House Ethics Committee or some of the federal law enforcement agencies that were mentioned, to understand their capacity and how much resources they would need to implement these policies. I agree with my colleagues, though. I think the simplest and the cheapest mechanism of enforcement is to implement an absolute ban on members and their families owning and trading individual stocks and other securities.
Thank you, Mr. Chairman. Yield back, Madam Chair.
Gentleman from Georgia is recognized.
Well, thank you, Madam Chair. And it's a very interesting hearing. I think that's something we should be discussing and talking about. But one quick question. I learned Mr. Sherman was part of the Ethics Committee just since I've been here. Curious, how many ethics violations were prosecuted per year? I mean, versus, I know that it's politicized and there are tons of ethics complaints for political purposes, but on average, how many years of members of Congress were we actually held accountable for ethics violations?
With apologies, I don't know the answer to that question. I served on the Ethics Committee before the Stock Act was passed.
Well, not just with stocks, with anything.
Would the gentleman yield? Because I was chair of the committee at that time, and we had a very vigorous enforcement mechanism at that time, one that Mr. Sherman was very active in.
Right. Well, I was wondering, it's just whether it's stocks or not, how many ethics violations do we catch people with that are prosecutable, or however the term you want to use, in a year?
Again, I would be guessing if I give you a hard
that's
answer.
fine, but there are some.
But there are some.
Which is a violation of an existing rule or regulation or law, correct?
Absolutely.
Okay. That's all I was wondering. I'll turn over to Ms. Schulp. Insider trading. Has there been insider trading done by members of Congress in the last few years?
There's been no prosecutions brought under the Stock Act provisions on insider trading.
So there were
but
some.
there have been members of Congress convicted of insider trading.
Right. So which is illegal.
Correct.
Okay. I'm kind of getting to a point, is a misconception that we have here is that government can change behavior. It cannot. Laws can't change or shape behavior. It can only punish for violations of those. And if we enact something like this that strips the rights and the freedoms of individuals, and everybody in this committee is a free American citizen that has rights, and part of the rights as explicitly defined by our founders was the right to participate in a free market society. The first stock market came in 1790, shortly after the ratification of our Constitution. It is part of a free market system. It's no different than having a bank savings account that you can draw interest. Now, I'm speaking from somebody, if you pulled the disclosures on me, and maybe you found that there were none. No stock trades. Why? Because the minimal stock trades that I do is below the threshold of reporting. And so it's not going to affect me what you do one way or the other. But let me also bring this up. It's ironic. I'm on the Financial Services Committee. And part of the oversight that we have is the stock markets, the SEC. There was an article that was written about me a few months ago or a year ago criticizing me that I have oversight and regulatory authority over the stock markets, and I don't even trade stocks. So how could I know anything about it? Versus one of the reasons I started trading a few stocks on my own so I could learn the intricacies of what I am doing. That's not a conflict of interest. That's using the interest I should have to further my knowledge to know what is right, what is wrong, how do we do this, how can we correct these things. Look, we cannot change behavior. At the founding of our country, there were 4 federal felonies. 4. Today, we have rooms of code books, of laws, but yet murders still happen. If government could change behavior, we would have no murders, we would have no thefts, we would have no fraud. So we can't change behavior. If we enact a law that prohibits members of Congress from owning or trading stocks, it will still happen by bad players. John Adams put it this way. He said, our Constitution is for religious and moral people, is wholly inadequate for the government of any other. What he was saying is basically the only way that you can control behavior is have such a strong and powerful government that it strips the freedoms away from everyone. If we have freedoms, if we have rights, you have to accept that bad people are going to do bad things, but you put the guardrails in for punishment of those things. So I'm just letting, whatever happens here, we have to keep in mind that every person in this room is an American citizen that has rights and freedoms, and part of that right and freedom is to participate in a free and fair market economy. And if you look, there are so many ethics controls on members of Congress right now. I think you're going to run some people out. And I want to take a few minutes to bring a different perspective on this for somebody who it's not going to make a difference to me personally, but it does make a difference to me as an American citizen. And yes, 70%. Look, if you polled a Republican district after it came out that the speaker's husband made all these millions of dollars on a stock trade, I guarantee you most of them would say, yes, ban it, ban it. But if you went to a Democrat area, it probably wouldn't be as much because people are emotional, and our founders put in a system that was slow and methodical. So we wouldn't react emotionally, but thoughtful based on law and protecting freedoms. And so, Madam Chair, I see my time has expired, and so I yield back the time I no longer have.
Gentleman yields back. Gentlelady from Pennsylvania is recognized.
Thank you so much, and thank you for having this hearing. I mean, obviously, the public's been appalled by the reporting we've seen about members of Congress and the Senate using inside information to profit themselves. The whole point of public service is to serve the public, not line politicians' pockets. But I do think there's a lot of usefulness in establishing firmer laws. I would have to disagree that laws have no impact. Thinking of smoking or speeding certainly set some guardrails, and when people know what the rules are, they follow them better. Certainly find myself in the unusual position of agreeing with the ranking member that we do need to do a better job of educating members of Congress about what those guardrails are, because the whole process of getting here is such a fire hose of information that this is not one that is well emphasized. A couple of you have talked about executive branch guidelines being maybe something we should be considering, and maybe we could start with Mr. Sherman. I know, Ms. Nagy, you also discussed this, and then if anyone else wants to chime in. Can you talk about how the executive branch guidelines with respect to stock trading might inform what we're trying to do here, and if there are any important differences we should be thinking about?
Sure. Well, the conflict of interest statute that applies to the executive branch but does not apply to Congress creates provisions that ban federal employees from working on specific matters where they have a conflict with their financial holdings. But it doesn't name specific securities. It's pretty broad. It applies to spouses and it applies to dependent children. And I think that is a good model for Congress, in part because we know Congress thought that it was important. I don't know why Congress opted themselves out of it, but I think that is a good floor, with the recognition, however, that members of Congress are differently situated than executive branch employees, because executive branch employees have the opportunity to recuse themselves from matters where there is a financial conflict. And again, with respect to members of Congress, it hurts your constituents if you are recused from any matter that is within the purview of Congress. It denies them representation, which is why the prophylactic measures for members of Congress should be higher, not lower, than applied to members of the executive branch.
Ms. Nagy?
Yes, thank you. If one is a member of the executive branch and one is charged with shaping health care policy, one cannot own health care stocks, full and simple. Sometimes it's prohibited by statute directly. Sometimes it's prohibited because of the conflict of interest statute that Mr. Sherman just took us through. Members of Congress can own stocks and shape health care policy, and they do. And they are complying with all current rules and all current disclosure requirements when they do, which says to me a change needs to be made. We have had instances where legislative branch officials, where lawmakers, when the president nominates them to move to the executive branch, has to sell their stocks because they can't do their jobs. But they went for decades doing their jobs here in Congress, and they were complying with congressional rules, which says to me congressional rules needs to change, and I think a federal statute is the way to change that.
Okay, it is interesting, since the scope is so broad. I mean, we have to deal with wars in Ukraine, and we have to deal with child care tax credits and everything in between. So that is an interesting distinction. I think you had something, Ms. Hempel.
Yes, I just want to, in addition to what my colleagues have said, I think it's also important, the executive branch provides a really good model for any particular exemptions or unique situations as they come forward. You know, I know people have asked questions about how would you handle cryptocurrency underneath these, underneath the new restrictions. I think the executive branch, you know, has provided a really good roadmap of how to do that. There are also questions about, you know, non-nuclear families and how would they be approached. The executive branch has had restrictions that are stronger in many ways than what's being considered right now for Congress, and has found a way to make it work, and has found a way to make it work without deterring successful people or, you know, people from the lower economic ring in our society in participating in the executive branch while under those stricter restrictions.
I have a gazillion more questions, also wondering how much public financing of campaigns would help, but thank you, and I'll yield back.
A vote has been called on the floor of the House. We have 2 votes. So we will recess at this time to go vote. It's probably going to take at least 40 minutes to come back. So you may want to go get a cup of coffee or something. And we have at least 3 members who have questions. And there's been discussion of maybe having a second round if you all are game to stick around for that. So at this point, we'll recess and we'll come back promptly after the second vote. Well, I think we have two members. Miss- Mr. Davis? Okay, oh, good. I guess we'll wait to the waiting for his gigantic stock portfolio, which he inherited as a child. I have never purchased or sold a stock, a share of stock. So in some ways, this is very much an educational experience for me on the nuances and the questions that are before us. I'm sure the ranking members had the same experience I have had, people asking questions, what about this, what about that, that by and large I don't have the answer to. So let me pose this question. Several people have, I think the goal is, if I'm hearing everyone correctly, is that a member of Congress should not be able to personally benefit financially from the information they receive because they're a member of Congress or because of the decisions that they're making as a member of Congress. And I think most of us agree with that. So the question is how to address that. And I think as people have asked me questions, it seems like there are more complications than it would seem at first blush. So let me ask the fundamental question, which has been asked to me: why stocks would be different than other assets? For example, we have members of Congress who are allowed, who own a business that they owned before they were elected, an insurance company or a store or any car dealership, whatever. And the decisions being made or the information received could have an impact on the value of that asset. We have members of Congress who have professional licenses. When I chaired the Ethics Committee, Mr. Sherman may remember this, you're not allowed to practice your profession as a member of Congress to avoid conflicts of interest. The medical doctors approached the committee with the point that if they didn't practice a certain number of hours, they'd lose their license and they would never be able to practice medicine again. And so we arranged for a scheme where the medical doctors could put in the number of hours that they needed to retain their license, and the remuneration could be no more than what was necessary to pay their malpractice insurance for doing those hours. And I think that's worked reasonably well. On the other hand, you know, Medicare reimbursements, a whole variety of things impact what an MD will in the future be able to expect as an income stream. Same with dentists or even attorneys. You don't have the minimum hour issue with MDs, but if you vote on something that provides for private right of action that's remunerative in the future, you could benefit from that. So why are those issues different than stocks? Whoever could answer that would be helpful.
Anybody else? So, well, thank you. So stock in individual publicly traded companies is the low-hanging fruit. And let's go after the low-hanging fruit. It would be great to go up the tree and get higher reached fruit, and as we do, it's more nuanced and it's more complicated. But a total of hundreds of millions of dollars of assets of members of Congress are currently invested in publicly traded companies' stock.
No, I understand that, and I think there's a genuine desire to address the issue,
Right.
but from a policy point of
So
view,
from-
what's the distinction?
So the policy distinction is if we rid that interest and shift it, because it's not completely abolished, it basically then the stock is held in diversified investment funds. And so, but members of Congress in a diversified fund would not have as much impact.
Okay, let me ask you this. Members of Congress, most American, middle-class American families, the single most important financial asset they have is their personal dwelling. And I think that's true other than the extremely wealthy people in Congress, and there are some, that's true for most of us. Obviously, there are a lot of things that can impact real estate. I mean, mortgage rates and the like. Should we require members to sell their homes?
So I think we have to recognize two things. One, there are conflicts of interest with respect to most of what members of Congress do, right? Members set tax policy, and presumably they all pay taxes. So I think how we have to approach this is a balancing test that takes into consideration the risk of a conflict of interest materializing in a way that impacts members in their representation of their constituents, as well as consideration of how large a pool of individuals the conflicts that members have impacts beyond them, right? For example, with tax policy, or with owning a home, or paying for college, right? These are things that affect the general public across income levels, across various different factors. And I think everyone agrees that it's reasonable to understand why members of Congress, are elected to make policy with respect to those issues without selling their homes or taking other extreme measures. With respect to individual stocks and other assets that are under discussion with some of these proposals, one, they impact a much smaller class of assets than the general public possesses in a much more substantial way. I don't think there's any way to compare the stock portfolio or the financial portfolio of the average American as compared to the portfolio of the—
No, I agree with that. So I am understanding your conflict rules, and I think they actually match the conflict rules of the House in terms of if it broadly impacts the public, it doesn't. But let's talk about businesses. Lawyers, I know a number of lawyers who are in the House, and if they were in private practice, they had to shut their practice down and lay off all the employees. Other people who don't have management of businesses, they can keep those businesses. Why would those businesses be treated differently than a stock portfolio because obviously most Americans don't own a business. How would that be dealt with, and what's the policy distinction, if any, being made?
I don't think they necessarily should. I'll give you an example from the depths of the ethics manual. With respect to recusal, there's a provision, an example in the ethics manual that says it's okay for members of Congress who own a brewery to vote on prohibition legislation. That seems like an obvious conflict of interest that any normal person could understand, that the congressional ethics rules not only explicitly allow, but articulate as an example of how Congress should function. I think that's a problem. I think there are lots of businesses and interests in privately held companies that present the same level of conflicts of interest that we are seeing with stock trades. As Professor Nagy said, I think we should handle as much as we can, as judiciously as we can, but that doesn't mean that other conflicts don't exist and shouldn't be addressed. I think there's a reasonable test and a line that can be drawn. We've seen it with small farms and things like that, but certainly they present the same conflicts that we're dealing with here.
Let me ask a question. Maybe this is a dumb question, but as I indicated earlier, I've never purchased any stock or sold any stock. If you look at my disclosures, however, it looks like there's all these stock trades. Well, what it is, my husband he's a lawyer, he's a sole practitioner, and he has a retirement fund that some guy at the bank manages for him. And I don't know what he's doing, and I suppose my husband could find out, but I don't think he does. We just say, don't buy fossil fuels, don't buy tobacco, don't buy gambling, and sometimes he doesn't even adhere to that. But that's not a blind trust, but in fact, we don't know what he's doing. Could you substitute the very burdensome, and we said, there are problems in terms of what you put into a blind trust, but the asset requirements and all the, the blind trust rigmarole with a more simple approach that you attest under penalty of perjury, the member, that you don't know and you're not directing and you're not receiving information, and the person who's doing the investing does the same penalty of perjury attestment. Does that work?
If I could jump in on this one, I think
Sure.
What the scenario you described, kind of where the holdings are in a retirement account, is not necessarily what we're talking about here. I think that would likely be in compliance with the current restrictions. I think the benefit of a blind trust is that there's a statutory definition there. The individuals, like you were saying, under penalty of perjury, but in there, it's the individuals administering the trusts also have a professional responsibility and will receive professional penalties. But to the point that you're making, that you don't own individual stocks, and Ranking Member Davis, that you made also kind of along those lines, that puts you in line with most of the American public. And again, I think the restrictions and how they would apply to members of Congress would not shut members of Congress out of the financial markets, as was suggested earlier. It would simply limit their ability to engage in those markets with financial instruments that don't pose those same conflicts as individual stock ownership do, and then would allow, and I think also to your point earlier about what is the goal here, absolutely the goal is to make sure that members of Congress aren't corruptly using information that they have, but I think the goal, it has to be a little bit bigger than that too, and it has to be that Congress crafts ethics rules and laws that are strong enough that the public doesn't even have to worry about whether or not that's happening.
It's the appearance as
well. The appearance of a conflict is as damaging to the integrity of the institution as an actual conflict.
Let me ask a couple of questions that I have been asked. If the goal is basically to keep the member of Congress in the dark, and if they don't know something, they can't act upon it, to overstate that. It occurs to me that to some extent, the Stock Act reporting undercuts that whole goal. For example, once a year, my husband grumbles about it. He has to fill out this form because I don't know what's going on. Once a year, I find out what he's been doing. I guess there's that value as a spouse. But otherwise, I would never know. So to some extent, the reporting aggravates the situation. And you have to report for tax purposes and then once again for disclosure purposes. Would it make more sense to align the dates of the disclosure so that the tax and reporting are at the same time, and you don't at least have two disclosures, that's something we could do by adjusting the disclosure time for members to coincide with tax time. Would that help some?
My understanding is that the reason why the FD date is a month out is so that members can file their taxes without having that butt up against the deadline for FDs. I think, frankly, taking a poll of members and figuring out if the intent behind that accommodation makes sense would be a reasonable approach to figure out if it should remain in place.
Let me ask a couple of questions that have been asked to me by various members, and I won't go into any names, but people wonder about this. Member of Congress is estranged from a spouse, not divorced, but it's obviously heading that way. The non-member spouse is engaging in rampant stock trading and will not comply with requests of the member spouse. What do you, I mean, should we have a provision where you can say this is out of control or we're estranged? I mean, you're going to hold a member accountable for something they can't control. What do we do with that?
Yeah, I think one thing to consider, or two things to consider with any exemption or potential exemption would be, well, one good roadmap is to look how the executive branch has handled it. Again, you know, they've had these similar restrictions for over 60 years. But I think kind of the bigger, broader principles for Congress to consider when thinking about this or any kind of exemption to these, to this rule is that any exemption takes you further away from what the American people are asking for. And so I think as a threshold matter, Congress should ask itself, could this exemption undermine public trust? And if the answer to that is yes, I think Congress should then ask, is it absolutely necessary that we figure it out in this legislation? Or is it something that we could do in regulation? But I also think if it has the potential to undermine public trust and is not absolutely necessary, I would urge Congress to resist the urge to address every individual instance that may come up, because I think it just further complicates a system that really benefits from simplicity.
That may be the answer that people have for the other specific questions I've been asked. People have asked about, what is it, 527, these education accounts? Is that the right code section? Would that be covered because members contribute for their children and for their grandchildren so they can go to college? And people are worried that, you know, most of the members of Congress could earn a lot more money in the private sector than they're learning here. We're not asking for a pay raise. We're just noting that if you can't support your kid's college application, you know, endeavors, and you have to quit.
So I think you're referencing 529
Yes,
savings
that's
plan
it.
for tuition. And the way those usually work is that you put in your monthly contributions or annual contributions, and it's typically directed into a diversified fund, sometimes an index fund, sometimes
So it's because
mutual
you don't control it,
Correct.
it would not be
You do
covered.
not control the individual stocks in the portfolio, in the basket of stocks that the fund would own.
And that would be true for retirement funds as well, I would assume.
And I think
Correct.
it's in addition to, because you don't control them, but also they meet definitions of being diversified, and so you're not having that. You don't have that same impact on any one particular sector or any one particular company as you would with individual stock ownership.
Okay, let me ask a question that's come up. You inherit stock. And I'll give you an example. We no longer have this stock, but my husband's Aunt Mary was married to an oil field worker, and it turned out that she had stocks in an oil company that Ed had received, and he had died, and she never had kids, so her nieces and nephews inherited it, which we didn't want. But what do you do when that happens, either for you or your minor children? You've acquired it, but not really intentionally.
Well, I would go back to what my colleague Ms. Hempelwitz said. I think we're designing a ethics regime for the legislative branch. We should start from the principle that public service is a public trust and establish as stringent and clear a rule as possible. There are always going to be unique family situations, as unique as the 535 members of the House and the Senate, but we can't develop an ethics regime like that. Certainly the ethics committees, if they are given authority to enforce these rules, can come up with some reasonable regulations that account for very specific and likely to occur exceptions, but I think we need to start from a general rule that
So we would leave that to, we're going to have to check with the Ethics Committee on their capacity to do that. I mean, for example, one of the questions I've been asked is, what if your spouse is employed in a company and their compensation is stock options? Do they have to work for free?
I think most of the proposals under consideration right now would allow for the spouses to be compensated in the way that their employers decide. I know you didn't ask this, but I will also just say explicitly, I think members of Congress should get a raise. It's important for government ethics. It's important.
Well, I appreciate that, but that's not going to happen. So we'll just make that very clear. There are many, many other questions, but I've taken more time than really is fair. I've thought about this a lot, and I appreciate the testimony because you all have a high level of expertise in this area, and I see the gentlelady from New Mexico has arrived, so we will turn to her for her questions.
Thank you, Chair Lofgren. And this line of questioning really highlights the fact that it's not easy, right? It is an area where we're trying to deal with multiple members of Congress who each have their own unique histories of why and how they came here. I will say that over the last few months, one of the top reasons why my constituents have been reaching out to me is that they want to urge a ban on individual stock ownership for members. So it is not something that is in a vacuum. We are dealing with our constituents are asking us to make sure that we have that separation, that we have that independence, and that our best interests in what we do financially is not at all tainted by what we do here. And, and I agree with that. I don't think members should be in the business of owning or trading individual stocks. When I first got elected, soon after it was brought to my attention that my retirement portfolio my 401k had a very modest amount in an individual stock. So I had to go in and actually take the extra effort to actually say, no, you can't get rid of that. I do not want to have there be any question at all. But as the chairwoman noted, I was not aware of that until it was brought to my attention, and I immediately asked them to turn it into something else. I don't know what you're going to do with it, just turn it into something else. But the other thing that strikes me is that we're talking about choice. I love the fact that that word came up a lot, because when we run, when we ask voters to elect us, which we have to do every 2 years, we are making a choice at that time. So if we know that we have a large portfolio of stocks, and if it is known in advance that once you get elected, you are going to have to divest yourself of those stocks, or put it in a blind trust if you have enough to make sure that you can pay the costs and deal with the complexity, that's a choice you are making when you are asking voters to trust you. And so we need to return that trust. And as long as we know that's what we need to do, then that comes part of the decision-making process. But there is an issue of timing. And so, like, how long would you recommend that a member of Congress, once elected, be allowed before they have to engage in that divestment, before, if they inherit something, what is reasonable then? I mean, because we want to be able to provide a period of reasonableness that everybody knows about. And I'll ask that of the panel. So I see several of you shaking your heads up and down. So what would you answer to that?
I'll be faster than I usually am. I think the important thing, again, to consider is and look and see how things have been handled in the executive branch. And so I think the timelines that are given there, I think might be a good indicator. I think also, some people have suggested that maybe any additional restrictions shouldn't go into place until a member wins re-election. And I think that may also be reasonable. I think we're certainly not trying to create an ethics program that's impossible to comply with. We're trying to do the the opposite. And it should be as simple to comply with as possible.
Right, and waiting until after re-election allows that member to make the choice as to whether they will continue to ask for that. Mr. Sherman.
I agree. I think the executive branch provides some examples. I also think that the time period should be with all deliberate speed, particularly relative to the 2-year term of service that members are elected to. So I've seen some proposals which are 90 days, 120 days. That seems not unreasonable, but I think with all deliberate speed is advisable.
And Professor Nagy, as you answer that, I have another one, and since I don't have a lot of time, I'll just see if you want to answer that. And also, I mean, we keep pointing to the executive branch and its models. Are there instances of something that's in the executive branch that doesn't quite fit within a congressional setting? And what are some of those examples?
So on the timing issue, I would say that I think a number of the bills actually, particularly for inheritance, raise 180 days as the time that someone would have to divest. And I think the consideration there is that sometimes the stock market is not doing what one wants it to do, and that gives a little bit of time there. I would also say for any divestment that is required under legislation that Congress enacts, I would also recommend the same type of rollover of capital gains tax that is currently in force, that Congress has currently put in the statute for the executive branch. I think that if someone sells assets, sells stock and other securities because they are ordered to do so, and they move that into a diversified mutual fund, they should the law should be written so that capital gains is deferred. Going to the executive branch, that is the rule in the executive branch. You know, I think what the executive branch has, because it is, in most instances in the agency, it's not an outright prohibition, although there are exceptions. The FCC is one exception, don't own telecommunications stock. The disclosure forms that executive branch officials complete allows the ethics agency to determine whether there is a conflict of interest or is not. And then that then triggers the need for recusal or divestiture. And clearly that's not the instance here. Mr. Sherman before referenced the sort of brewery example that is codified in the manuals there. The House and Senate Ethics Manual reference stock ownership and explicitly say that divestment is not required even if members own stock in companies that directly and substantially affect the legislation. So the problem is greater than the current law allows this. It's that the problem is that the current rules in the House and Senate safe harbor this.
Thank you. My time has expired, Madam Chair.
Thank you. Gentlelady yields back. Ranking member is recognized for our second round.
Thank you, Madam Chair. Again, this is a great hearing. I do truly appreciate the witnesses. Going back to our previous conversation, I think what we're hearing from our witnesses is that members have a choice. You can either go into a qualified blind trust that I've already established. I and most members of Congress would never qualify for one company, LPL's minimum investment of $500,000. Don't have it. Most members don't. Or divest individual stocks that then will get accused of getting a special privilege of deferred capital gains. So those types of, you have to take into consideration what the perception is when you all come up with what you think might be a great idea for Congress, but we're in a different perception. That crew might call us corrupt if we take that tax break. Who knows? I'm focused on the middle class member, and I just don't believe that forcing middle-class members to divest an ownership portion of a family farm or to divest ownership in a business that their spouse may be a part of, their dependent children, I just think it's untenable. Would you all agree that your proposals are mainly geared toward the wealthiest members of Congress?
I wouldn't say so.
Okay. All right. Ms. Nagy, you testified earlier you don't believe the ballot box is sufficient. to be a check on members of Congress, drawing analogies to different rules with different branches of government. I want to point out that only 2 people in the executive branch are elected, 0 in the judicial branch. We've had no discussion on the judicial branch right now. I don't think that analogy compares apples to apples. I mean, we're accountable to 800,000 people every 2 years. We have a job interview called an election.
So my testimony before was that the ballot box is not a sufficient remedy to ethics, because ethics affect the nation, affect everybody. And so if a member has conflicted investments and is generating a public perception that the reason he or she is advocating for legislation is to juice the value of their portfolio, that's a national problem. And the fact that
That's a
small
corruption
district—
problem. That's, again, those corrupt members. But most
That's not corrupt. It's allowed. If I may just respond, it's not corruption. It is currently completely within the House and Senate rules. Do not prohibit a member from owning stock or owning an investment and advocating for the direct benefit of that investment, unless, and there is an unless they are the sole beneficiary of that legislation.
Do you have a number that your research has put forth that would determine how many members of Congress are doing that?
How many are doing that?
How many are
How many
actively
people
doing
are advocating for legislation because it benefits their
Yeah.
own portfolio? I'm not sure how that can be quantified.
If I may.
I agree. Hold tight. I appreciate it. I'd be glad to get to you. I'm a limited amount of time. I don't control the committee. But this is a great time to be able to ask a lot of different questions. So as we look ahead, all right, let's look back. So we were coming into a pandemic, right? We, in a bipartisan way, virtually unanimously created the Paycheck Protection Program. Benefited a lot of small businesses that are attached to stocks maybe members own. Should every member of Congress, because they may have voted for that program, was that a corrupt thing because we tried to save the economy? Is that something that you can go back and say members of Congress benefited? I mean, in my particular case, I was accused because my family members got PPP loans of trying to benefit my own family when I have no financial interest. But that's settled in the election. I mean, I think you can try to find a connection to everything we do. But again, most members of Congress, I truly believe Republicans and Democrats want to do the right thing. I don't trade stocks because I don't want to have to fall into some gray area of a reporting issue. But I think there's an issue that we don't start with what we have. We follow transparency rules. We file ethics disclosures that most people in the American public don't. So with that in mind, one last question, and I know, Mr. Sherman, you have probably more experience with this than most. Knowing the ethics disclosures that all of us file, and they're easily available, did any of you go research mine while we were breaking? Darn it, I was hoping you would. You could get it easily. And then we have the Stock Act transaction paperwork that I've never used, but others have. So I don't know anything about that, but I file my own ethics disclosure because I want to go talk to the ethics committee staff to make sure I'm doing everything right. But is there anything in our current disclosure requirements that is lacking, that you would say needs to be more transparent? And if so, what is it?
Yeah, so I appreciate the question. One, I would note that the only way to really know if a member is acting on a financial conflict of interest is to see their communications about that policy. But Congress is exempt from the FOIA, right? So when you talk about true transparency, I think there is some transparency, but the transparency with respect to members of Congress, how laws are made and their financial conflicts of interest, pales in comparison to the executive branch. I would also note that with respect to financial disclosures and periodic transaction reports, they are accessible to, I think, the folks on this,
What are they missing?
side.
What are they missing?
I think they're not easily accessible to the general public. They're not machine readable. You can only view one document at a time. So if, for example, one of your constituents wanted to review all of your transactions over the course
Okay,
of
so
your tenure,
you have an accessibility.
they cannot easily do that.
You have an accessibility based on something that can be fixed, make it more searchable and sortable in the Clerk of the House website. But I'm talking about the disclosure itself.
Sure.
The
Disclosure does
itself
not
is
correct conflicts.
Is our ability as members of Congress. It's our ability to tell our voters and tell every person in America, here's our financial picture for our entire household. Here it is. Chairperson Lofgren, she laid out how her personal situation is each time that ethics disclosure comes. I know what mine is because I do it. But what on that disclosure, what are we not doing that gives corrupt members of Congress the ability to hide wealth or hide trades or hide something that you, as a former ethics committee attorney, you used to see these corrupt cases, right? Mm-hmm. What is it that you would recommend we do to fix the current transparent process? Because I think that's a key point that in a lot of recommendations, we start from where we are today rather than where we were before this transparency existed. And we start at a point rather than looking back and saying, what can we correct to make the periodic transaction report better? What can we correct to make the ethics disclosure PFD better?
I think, as I said, making them more easily accessible to the general public, machine readable, but also we've had, as you mentioned, 59 members of Congress violate the Stock Act since 2019.
So we got to do a
whatever
better job.
enforcement mechanisms are in place clearly aren't working. Maybe there's education as you mentioned, which I think is incredibly important, but the penalties aren't high enough to promote the compliance that I assume that members want and that the public is demanding.
I'm going to ask you guys one more time, and anybody else can answer this. This is my last question. I'm sorry, Madam.
That's why I was going
Thank
to
you.
ask if you would yield for a follow-up.
I will yield.
On that, because we have had a lack of compliance, and one of the things I'm thinking about, could be somebody trying to hide something, or more likely, somebody just messed up. And that the penalties, it's the same amount of penalty, whether it's a $100 trade or a $1 billion trade, and maybe we ought to stagger or phase the penalties based on the dollar amount.
And that's something that as we develop what would be a final piece of legislation to address these issues, I'd love to work with you on that, Madam Chair. But where we are right now, I mean, Congress today versus 25 years ago is much more transparent. I actually led a group when we were in the majority that made every MRA expense searchable and sortable. I mean, even the most liberal, good government groups said nice things about me. I know it was tough, but they did. I know. But there's got to be within the existing system. I mean, is there anything that we can do within the existing disclosure system that can be more transparent about what members of Congress, what we do? Because, we want to follow the rules. And just immediately changing the rules, telling people you got to divest in your family farm, you've got to divest in your family business, you've got to divest in a stock that you may have inherited. I will tell the chairperson, I will gladly take ownership of any fossil fuel stock she inherits. I will hold that for you.
My husband sold it.
I will take care of it for you. But in the end, we want to do the right thing. We all try to do that right thing. What is it that we have in place today that can be better and could show what is happening in our financial picture that may not be shown today?
Ranking Member Davis, to your question, the transparency requirements currently on Congress have been enormously helpful in highlighting to the public that members of Congress own and trade individual stocks. And that's the issue that the public keeps rising up about and wants their voice heard on. It's not that they care about missed filing deadlines or that they are concerned that members aren't aware of the current rules. It's that every step of the way when the public becomes aware of what those current rules are, they're outraged that members of Congress are allowed to engage in this behavior. And so I think just focusing focusing on additional disclosure requirements or the existing non-prohibitions in the Stock Act would be a tragically missed opportunity to engage with the American people on something they care a lot about and have told Congress they would like to see you act on.
I would argue that both Republicans and Democrats here, we engage with the American people on a regular basis. And Ms. Nagy, did you have a response to that?
I did. I would just echo my colleague's statement. Assuming timely reporting, the problem is not what is hidden. The problem is what is in the sunshine. And the sunshine is causing individual constituents to question not only their members' decision-making, but the entire Congress, or at least the large group that doesn't already have their assets diversified into widely held funds. Constituents are questioning, and members of the public are questioning, what was the motivation that prompted the push for this legislation? And that's in the sunshine. It's not hidden. It's in the sunshine, and that's troubling.
Ms. Schulp, did you have any comment on that?
Yeah, I have two comments to that. And one, we keep coming back to the question of diversified funds. And I think it's an interesting, good question that we keep coming back to. But keep in mind that some of the questionable trading that happened during the COVID pandemic was in diversified funds. So the problems that we're discussing and the conflicts that exist are not non-existent in diversified funds as well. It doesn't magically take care of the question of a conflict. On the question that you posed directly with respect to what could be better in the disclosure now, I think the long lag between the time that trades happen and the periodic transaction reports are required to be filed is something to take a look at. And where I've had interactions with the public, I've heard calls for more timely and quicker disclosure on that front. Corporate insiders are required to disclose within 2 days. That's not a completely comparable situation to Congress, but having 30 or 45 days after a trade takes place is an exceptionally long period of time after that trade takes place for disclosure to happen.
Yeah, I will end by this, and again, thank you for giving me so much extra time. I do believe this discussion is extremely important. I look forward to working with each of you individually as we move forward. But I will tell you, and I certainly hope this hearing allows my constituents more of an opportunity to think about this process. And I can tell you, I travel a lot when I'm home. I haven't had a lot of constituents bring this up. I hope they do, because I want to explain to them the processes we have in place and get their opinions and their ideas. And I certainly hope those of you who have already put proposals together for divestment and qualified blind trusts that we cannot afford, that most members cannot afford to participate in. I hope you're willing to listen to how we can make the process better and do it in a way that doesn't just encourage the ultra-wealthy to be the only ones to run for Congress. So with that, yield back.
Gentleman yields back. Mr. Aguilar, you're recognized for a second round.
Thank you, Madam Chair. And I'm happy to continue down the path in the conversation specific to kind of education and compliance. Mr. Strauss, we've been talking about the PTRs, the periodic transaction reports, and the 30 days of covered financial transactions. What remedial measures does the Ethics Committee have in place in the event that a member or a staffer files a PTR incorrectly?
So thank you for the question, and my colleague, Mr. Sherman, may know more specifics of the details of some of this stuff, but in general, when a filing happens, whether it's a PTR or a financial disclosure report, and there's an error on the form, which I'm led to believe is not uncommon, right? They're complicated forms to fill out. The committee reviews the forms, notifies the filer, and the filer has time to correct that filing. Most errors that occur on financial disclosure forms are de minimis errors, things that are put on the wrong line, just mistakes that happen. And once that filing is identified as being wrong, an amendment can be filed. The Ethics Committee is very clear that filing an amendment in and of itself does not have anything to do with potential wrongdoing, that most of the time, and a member or a staff member can file an amendment on their own too, if they realize that they've made an error without prompting. It's only after the potential that an error can be fixed, if someone chooses not to comply, that's when the committee might get involved in working with that person, either directly or indirectly, to figure out what's going on and whether a potential recourse might be necessary or not.
Mr. Sherman?
I think every staffer on the Ethics Committee remembers getting that one call from a member about a question about the form that they submitted. Mr. Strauss is exactly right. Members file their FDs and PTRs, and there's a process to work with them to make sure that the information is accurate, and if there are questions, they are asked. There's an opportunity to amend. And I think even on the investigative side, particularly with financial disclosures, I think there's a presumption that we need to make sure that this form was filled out accurately and correctly, and there's sort of a lean towards, presuming that members sometimes make honest mistakes, which we all do.
With respect to, Mr. Strauss, with respect to the remediation process, how does that differ within the executive branch?
So a designated agency ethics officer in the executive branch has prescribed tools that are potentially available to them depending on individual circumstances. So when a filer puts a financial disclosure form into their DAO, their designated agency ethics officer, and it's reviewed, the ethics officer is going to work with that individual on a case-by-case basis to choose the best remedy available, which could be divestiture. It could be recusal, as we've talked about. It could be the creation of a blind trust, but it also could be a voluntary transfer, right, to another job within an agency, depending upon what the circumstances is. And so those agency DAOs have a lot of flexibility to work with that individual to come up with a solution that works for a particular case, depending on their financial situation based on what's in the disclosure.
I appreciate it. Mr. Strauss, CRS is known for their education, for helping us at every step of the way. The ranking member talked about opportunities for new members to receive information. What would you envision? What does a training session on this look like? How should we think about scaling up the member educational pieces of this process? No matter what road we pick, what should that look like?
Well, first, I would say that I don't, nor CRS presumes that education is not already occurring, right? And that there are requirements for that educational process to take place. In the executive branch, the Office of Government Ethics works very closely with the designated agency ethics officers in each agency to train them so that they can then train the staff within each agency. So ultimately, the ethics committee is the one responsible for holding those ethics trainings and for deciding the type of educational content, right, that might be included within that process, both for members and for staff. I've never taken that training, certainly not the member training on that particular topic. But to Mr. Davis's point earlier, I mean, more education is almost always preferable in these types of situations. And probably the advice I give offices that call more often than anything else is, when in doubt in this space, ask for permission, don't ask for forgiveness. Call the ethics committee's advice and education staff and ask them, rather than presuming to know what the answer is, even if you've gone through that training, just to make sure you're on the compliance side of whatever the circumstance might be.
Yeah, my situation is similar to the ranking members in that, I handle this document because it's about, me and it's about my circumstance and my household. I want to make sure that I do this right, but that often means I'm reaching out to the committee directly and filing this as well. So, but I do think that there's a lot of space on the education side. The policy piece is why we're here, and it's something that we have to do, but I know that the chair, feels strongly about giving members the tools to do this job successfully, and I think that there is some space to do some more on the member side. Thank you. Yield back.
Gentlemen, yields back, and we've had another vote called on the floor, so I will just make a couple of comments. I think, I don't remember which witness expressed concern, but I know it's been expressed among certain members that we not hold up whatever we're going to do relative to the legislative branch for changes in the judicial branch or the executive branch. I don't think we should hold this up for that. On the other hand, I don't think we should hold up reforms in those areas too. So the obvious answer is not to put them all in one bill, but to let the processes move forward. And I think there's very strong evidence that we need additional measures in the judicial branch. I don't think it should be combined in one bill with this, but I don't think we should hold it up while we're working on this. Real simple question, and you know, the ranges on disclosure, I've never understood that. It's like, okay, you between 0 and 10,000, well, if it's $5, it means one thing, and if it's 10,000, it means something else. And you really can't tell what's going on. And then for people who are very wealthy, it's over 50,000. Well, maybe it's $1 billion. That would be something we'd like to know. What's wrong with just doing the actual dollar amount in the disclosure? Is there a reason for this?
I think sometimes it's hard to be accurate, and members definitely don't want to be inaccurate. But I agree with you. I think the demarcations could probably use a little bit of work.
Okay. I'm going to close out and just say that without objection, the following items will be included in the record of today's hearing. The February 17th, 2022 CRS report, a letter sent on March 28th to House leadership and this committee from 19 good government organizations, an April 7th, 2022 letter to this committee from the National Taxpayers Union, an April 7th, 2022 letter to me from Representatives Krishnamurthy, Ocasio-Cortez, and Nagus, and a March 17th, 2022 Wall Street Journal article, Dozens of Federal Judges Had Conflicts, What You Need to Know, a December 10th, 2007 Kansas Law Review article by Professor Megan J. Ballard, The Short-Sightedness of Blind Trusts. I would note, and we've had a lot of discussion about education for members. As you know, this committee is tasked with having a new member orientation, which we take very seriously. We had significant training and information sessions on this and many other things over a 2-week period. Among other things, we had the Ethics Committee come in and discuss all their obligations, and a discussion of the disclosure forms and the PTR reports and the like. However, as our only freshman on the committee said, it's like a fire hose at freshman orientation. So the ranking member and I have been gossiping that maybe we should do a separate webinar or something of that nature on this, similar to what we've done with the Congressional Accountability Act that every member has to do once a Congress or something of that nature. We can work on that without legislation, obviously. I will note that we very much appreciate our witnesses' time. I know it's been a little disjointed because of floor votes. We'll ask if you would remain open to additional questions that we may send to you. The hearing record will be open for your responses. And I don't know, Mr. Davis, we've got a vote on the floor. Anything you want to add before we adjourn?
Thank you very much. I certainly do look forward to sitting down with each of you individually and talk about how we can make processes better.
Thank you very much. Again, appreciation for the witnesses, and without objection, the Committee on House Administration is adjourned.